Hello, I hope you're having a great day. This is Dr. Bryson, your nerdy criminal justice professor, with another video for the corrections class. In this particular video, we're going to talk about prisoners' rights or inmates' rights. Now, it's important for us to understand the term that's in the textbook. It's called the principle of least eligibility. And what that principle states is that a prisoner should not have things as good as the least person in the community. In other words, if we think about really, really poor people in the community, the prisoner should not have more than that person does. It seems, quote, unfair for someone who has been duly convicted of a crime through due process to have more than someone on the street who has not been convicted of a crime. Um, Now, that's been the principle, but it hasn't really been active in the way that we might think for a long, long time. But what I really want to talk about today are court decisions. Okay, court decisions that really do away with something that I don't recall seeing in the textbook. I went back and reviewed it and I couldn't find it in there. But the idea of the hands-off doctrine. Throughout the 1800s, the courts had what we call the hands-off doctrine. That is, inmates technically were not permitted to sue for their rights. The courts just didn't accept that and they wouldn't take the cases throughout the 1800s. It was very rare. And even then, it was more likely to be juvenile cases, and very few of those cases actually came to the attention of the U.S. Supreme Court. But as we get into the early 1900s, we start to see some cases, and we're not really going to talk about those prior to the 1964 case um, of Cooper v. Pate. So Cooper v. Pate is very important as a Supreme Court decision, but we're going to talk about some of these. So the hands-off doctrine continued until we get into the early 1900s, and then there were a few cases that the Supreme Court was willing to hear. But in 1964, the case of Cooper v. Pate made it into the U.S. Supreme Court. This involved a Muslim inmate who was not permitted a Quran or to practice their Muslim faith. So they sued, and they were able to get all the way to the U.S. Supreme Court. And the U.S. Supreme Court said that they would hear prisoner civil rights cases. And the idea of freedom of religion was extended to prisoners. They had freedom of religion. Now, it's important for us to understand this because if you remember, the penitentiaries were founded by the Quakers who were Christian so that convicts would do penance, hence penitentiary, a place to do penance. So the idea was that they were supposed to be Christian institutions of hard work and Bible study. Well, hopefully by now, in looking at the history of prisons already this semester, you know that that went by the wayside pretty quickly. However, the idea of religion in the prisons was still considered Christianity was it until 1964 in the case of Cooper v. Pate. By the way, 1964 is the year I was born. During the week before spring break, I turned 62 years old. That's how old your professor is. So Cooper v. Pate is the same age as I am, just to throw that out there. So there were several other cases. So in the 1970s, in Wolf v. McDonnell in 1974, the U.S. Supreme Court, and I want to make sure I read this properly, and this is in their court decision. There is no iron curtain drawn between the Constitution and the prisons of this country. Now, the term iron curtain was borrowed from a term that Winston Churchill coined back in the late 1940s, early 1950s. I can't remember the exact year. It was between the two times when he was prime minister, but he was touring the U.S. on a lecture tour, and he referred to the free world and the communist world as having an iron curtain that fell between them. So the Iron Curtain was this idea that the communist world and the free world did not interact in positive ways, only in negative ways. That is the Cold War. Um, so the idea then was that um, um, when the Supreme Court decision is that we shouldn't have that in the U.S. between the courts and the prisons. The Constitution still applies. Doesn't mean that all rights are retained, but some are. So that was Wolf v. McDonnell. Now, when we fast forward to 1987 and Turner v. Safley, the Supreme Court then said that constitutional rights are valid for inmates. However, institutions can limit them if they are reasonably related to the legitimate, I want to get this right, legitimate penological interests of prisons. In other words, the right to bear arms. We need to make sure that prisons are safe. We try to avoid violence in prisons. Well, everyone who is a resident in a prison has been convicted of a crime. So, no, we're not going to let them have weapons. We're not going to let them have arms, so to speak. So we have a legitimate penological interest there. When I was at Lakin Correctional Center for Women in West Virginia as a therapist, we had a group of inmates that wanted to sacrifice an animal as part of their religious rites. Well, we have a legitimate penological interest, but we also had animal rights groups weigh in and say that they cannot support such a move. So we had a legitimate penological interest not to allow the weapons or the instruments of sacrifice, but we also had other laws that protect the torture of animals. So there are limits, excuse me, to the rights that inmates may have based on legitimate criminological, or I'm sorry, penological, I'm always saying that wrong, penological interests. I'm always having to look over at my notes on my other screen. Okay. But anyway, so that's a very important thing to keep in mind. And since 1987, and here we are, 39 years later, that principle is still at play. Well, I hope that you learned from this video, and we will see you next video.